I don't raise my hand or
So
do
you're
anything.
not going to take the oath, in other words.
No, I will, but just not as I'm not forced to assimilate to how you guys do things. That's
The way we do things is for you to raise your hand so you can make that affirmation. If you're refusing to raise your hand, then you're not making the affirmation.
well, then that'll be a violation of the American Declaration of the Rights of Indigenous Peoples. I have the right to self government. That is federal
Okay.
law as well as
Then
international.
I,
You, as a agent of the state, are required to make um what is the word? You're required to make certain accommodations for uh, foreign individuals in regards to the handling of uh, court cases or court manners, or I'm not sure the proper term, but you're required by law, state law, federal law, and international law to accommodate me in my religious beliefs and my religious way of life. Because if you don't, that'll be a violation of my life, liberty, and pursuit of happiness. It'll be a violation of uh, the uh, Bill of Rights, Amendment One, um, the First Amendment.
how do
Um,
you, um, sir, think that you can bring up the Constitution and your rights under it at the same time that you say you're foreign and it doesn't apply? That's always been a question I have.
well, the issue is because though I am foreign, the Constitution is the supreme law of the land to you.
Before this hearing even begins, let's set the stage, because what you're about to watch is not just a standard landlord-tenant dispute. This is Country Meadows Apartments versus Tarek Day and Erica Witherspoon, a non-payment of rent case that very quickly turns into something much bigger. On one side, you have a property management company claiming thousands of dollars in unpaid rent. On the other, a tenant who insists the landlord violated housing codes, endangered his pregnant wife's health, and lost the right to collect rent altogether. But here's where things get intense. Mr. Day doesn't just argue repairs or habitability. He challenges the court's authority entirely. He repeatedly asserts that he is not a United States citizen, claims to be a foreign national, and argues that state law does not apply to him. That puts Judge Washington in a difficult position, trying to keep the case grounded in Michigan landlord-tenant law while facing arguments rooted in sovereign citizen-style legal theories. At the same time, there are legitimate issues buried beneath the chaos: claims of code violations, escrow rights, chemical exposure, and a 9 months pregnant spouse with documented sensitivities. So the real question becomes, where does lawful tenant protection end, and where does courtroom defiance begin? As you watch this unfold, pay attention to how Judge Washington navigates patience, procedure, and escalating tension. Ask yourself, when a tenant believes the system itself is illegitimate, how does a court even move forward? And more importantly, who actually has the stronger legal footing here?
Good afternoon. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over the session. The court will call the case of Country Meadows Apartments versus Tariq Samar, Tarika Day, and Erica Witherspoon. Case number 23C0276.
Good afternoon, Your Honor. Christopher Borgen appearing on behalf of the plaintiff.
Hello,
Hello, Mr. Day. Please state your name.
uh, I'm Tariq Smart Tyreek Day.
Thank you, sir. All right, we're here today for a hearing regarding what I see as a non-payment of rent case.
Yeah, we just got a notice from the representative of the county because this apartment is in violation. I could send the email to Mr. Borkin. Um, it's from building official designee Carcom. And it states notice is hereby do not remove under penalty of law. Notice is hereby given that this occupier rental property is in violation of provisions of the Property Maintenance Code and Rental Property Ordinance, Chapter 48, as indicated. Date and time 3/24/23 at 10:35 a.m. Notice to tenants, you are not required to leave this building, but you can put rent money in escrow until this posting is removed with permission of the ordinance enforcement officer. Contact legal services to learn more about this process. This further validates the reason why I issued the correspondence that I sent to you privately as well as to Mr. Borkin, that Country Meadows has not held up their end of the contract and has been in constant violation of the contract. And I'm here today seeking a judgment in the matter.
Well, so you can't seek a judgment in the matter. That's not how that works. But I am hearing you when you say that the apartment is not apparently up to code. We'd have to see that documentation.
The lady just left a few hours ago.
Okay. Mr. Borkin, I presume since the notice was just provided, you and your client have not received that, or are you aware of any of the information?
That's correct, Your Honor. This is the first time hearing of any notice.
That was the reason for the withholding of rent, along with the main issue, which I notified the management about, as well as Mark Landau and Mr. Borkin. I've issued what we are expecting to take place, and if it doesn't take place, then we'll be moving forward with our counterclaim in civil court. If I'm not able to do it orally here today, which I also validated, not validated, but also placed into the correspondence that I sent to all parties in the matter.
Sir, you have not filed anything entitled a counterclaim. Documents have to follow the court rules.
Well, it's in contrary to that belief, as I stated on our last call, I'm not a United States citizen.
Sir,
I'm a foreign
you
national.
don't get to use the laws when they apply to you and not use them when.
First and foremost, not to cut you off, ma'am.
That's exactly what you're doing.
Well, when I'm able to speak, and I'll speak then.
Mr. Borkin, if there's a problem with the apartment, he's entitled to place monies into an escrow account. I have not inquired about what that escrow looks like or whether they're doing that or not.
This is a crucial moment, and it's where a lot of viewers get confused. So let's break it down clearly. Under Michigan law, tenants can withhold rent only under very specific conditions, and placing rent into escrow is not optional. It's procedural. That means the money must still be paid, just held by the court or an approved escrow account until the alleged violations are resolved. Judge Washington is doing exactly what she's supposed to do here. She's acknowledging that if the apartment truly isn't up to code, Mr. Day may have rights, but those rights come with responsibilities. You can't simply stop paying rent unilaterally without following the statutory steps. That's why the judge asks for documentation and whether escrow was properly established. This is also where the credibility battle begins. The plaintiff's attorney points out that his client was never notified of escrow, which matters legally. Courts don't operate on assumptions. They operate on paper trails. And without proof of compliant escrow payments, withholding rent becomes extremely risky for a tenant. So here's the question for you. If you believed your apartment was unsafe, would you trust yourself to navigate escrow law without an attorney? Or would you risk everything by handling it your own way?
I think what we need to do first is get a copy of whatever documentation you were served with today, Mr. Day.
Okay. I don't want to take it off the door because it'd be against the law, but I took a picture and I can send it via email to Mr. Borkin. And if he wants to get that to your email or to the clerk's email, I don't have a clerk's email or your clerk's email, but I could email that as soon as we go.
You email it to Mr. Borkin. You have his email address.
I do.
All right. Can you email it to him, please?
Yes, ma'am.
Your Honor, I would point out with this notice and any other notice, if rent is being placed into escrow, it's not something that my client has been made aware of. It's not something that's followed the Michigan law for placing rent into escrow. And I would just ask the court to take that into consideration.
Thank you. I want to review the documentation that we have here.
Do you want me to send it now so you can get it, or is this going to be scheduled out for? Oh,
I want you to send it now, please.
no problem.
While he's sending that documentation, is it true that the balance at this point is $1,083?
That is not true. I have the last ledger I received. It still shows a balance of $3,700.70. Correct me if that is not accurate any longer, but that is the latest ledger that I have.
I guess the other question that I have is, I know that you filed a host of documents with the court today, Mr. Borkin. Were those documents also provided to Mr. Day?
I did neglect to forward them to his email. That was completely my mistake. I'm realizing I can do that now. The only documents I sent was Mr. Day's lease.
It's just the lease. Okay.
But I also had questions in regards to the correspondences that I sent. None of the claims that I put on record have been addressed by the plaintiff.
Mr. Day, I denied that motion when you were here last time. I'm not going to readdress it.
Excuse
And
me.
it's not in your best interest to go down this road.
Well, are you giving me legal advice, or is that a threat?
I'm telling you that it's not in your best interest to go down this road.
And I'm asking, are you giving legal advice?
What is your point, sir? What do you want to say? That if you're still going down that road, what's going to happen is you're going to have a problem with your case. That's what I'm telling you.
So you're giving me legal advice?
That is not legal advice. I'm the judge. I'm going to make a ruling, and I'm telling you that it's not in your best interest.
Well, I don't agree, and I feel that I've already filed
I already denied that motion.
I'm not talking about the affidavit. I'm not talking about the affidavit. I'm speaking on your judicial capacities. I've already filed a complaint with the Judicial Tenure Commission in regards to how you're handling this case.
That's fine, sir.
So you will be under investigation for that. And also,
Okay.
as I've stated, I'm not a United States citizen. And
Sir,
no,
I'm not going to deal with that motion again. I already told you that that does not apply here. You're going to be under the laws of this land. I'm done with that.
Excuse me, ma'am. The laws of the land is treaty law, which I'm under, which supersedes state legislature codes and statutes. I am, as I stated before, a foreign national, and I'm under the Constitution of the Moorish Republic of Peace, which supersedes state law.
This exchange marks a turning point in the hearing. At this moment, the case stops being about rent and repairs and becomes a direct confrontation with the authority of the court itself. Mr. Day repeatedly claims that he is a foreign national, governed by treaty law and a separate constitution, and therefore not subject to Michigan statutes. This is a line of argument courts see more often than people realize, and it almost never ends well for the person raising it. Judge Washington remains firm, calm, and professional. She makes it clear, if you are appearing in this courtroom, this court has jurisdiction. You don't get to selectively invoke constitutional protections while simultaneously rejecting the court's authority. That contradiction is exactly what the judge points out, and it's a legally fatal one. What's notable here is Judge Washington's restraint. She doesn't escalate. She doesn't threaten. She simply states the ruling and moves on, even as Mr. Day accuses her of misconduct and files complaints mid-hearing. So here's something to think about. At what point does asserting rights stop being a defense and start actively harming your own case?
And for you to continue to pursue the matter is a ultra virus act. Um, I am, as I stated before, a foreign national, and I'm under the Constitution of the Moorish Natural Republic of Peace, which is supersedes state law.
Okay, dokie. Are you going to provide the documentation or not, Mr. Day?
Yes, I thought I just sent it.
I don't have anything in my email, Mr. Day.
Okay, hold on one second, sir.
Your Honor, while he does that, would it be possible for me to address the beginning of the time frame that he started withholding rent in this matter?
Are you by that? Are you meaning? Can you ask him when he started?
Well, I believe it was in around November or December, and Mr. Day would
January.
around January of this year. Is that correct, Mr. Day?
January.
Your Honor, Mr. Day's counterclaim revolves around my client's use of cleaning chemicals in common areas. My client has made all efforts possible to prevent the cleaning company from using this cleaning chemical, but there have been a handful of instances that they have neglected to listen to my client's words, and they've used the chemical anyway.
When you
Mr.
say counterclaim, do you have something that I don't have? I don't have any document labeled a counterclaim.
Maybe perhaps I'm crossing a line here, Your Honor, a bit. It was unclear to me what was made on the record and what wasn't. In terms of a rental abatement that the defendant would be seeking, the basis would be steeped in repair issues. But I don't have that in writing. That's just been based on the discussions that I've had with Mr. Day.
I see. So the basis for the notice today, you're saying, is about cleaning products?
The notice from today is because of repairs that, along with the cleaning products, is the reason for the withholding of rent. The repairs. I'm sorry.
Lack of repairs.
Yes, these are things that I've been in contact with Country Meadows for since last summer in regards to the repairs that need to be made. In regards to the cleaning supplies being used, my wife is severely allergic to certain, well, mostly all kind of perfumes, chemicals, and things of that nature. Her throat will begin to seize up or close up, excuse me, and it's detrimental to her health. She's 9 months pregnant. Her water just broke yesterday, and the most recent time that they cleaned was at the beginning of the month. Again, using the same chemicals, Fabuloso, which I have pictures and picture evidence of, and documentation of how Fabuloso has been recalled. All Fabuloso products have been recalled since last year. This year.
This is arguably the most emotionally significant portion of the entire proceeding. For the first time, the focus shifts away from abstract legal theories and onto real human consequences. Mr. Day explains that his wife is 9 months pregnant, that she suffers severe reactions to cleaning chemicals, and that her health has allegedly been compromised by repeated exposure. If true, these are serious allegations, and Judge Washington clearly recognizes the gravity of that claim. But even here, legal structure matters. Emotional weight alone does not replace evidentiary requirements. The court still needs sworn testimony, verified documentation, and a clear causal link between the landlord's actions and the alleged harm. That's why the judge is so focused on procedure, oaths, records, and proper filings. This moment highlights the hardest truth about courtrooms. Even when someone may be suffering, the law still demands order. The system is designed to protect rights, but only when those rights are asserted correctly. So ask yourself, should courts bend procedure when health and pregnancy are involved, or does consistency protect everyone in the long run?
Continuing into this year and up until recently. So, as I stated to Country Meadows and Mark Lando and Mr. Borkin, that if the issue is not going to be addressed, then we will be seeking damages for our inconvenience and our inability to properly inhabit the property, and it is a violation against our enjoyments of being able to be here uh, without worrying about health issues or repair issues or things of that nature. So yeah, I just emailed Mr. Borkin um, the citation or documents. I don't really know what to call it from the Washtenaw County representative. Um, so I mean, if he wants to give it, pass it on to uh, Country Meadows. They're already well aware of it. This is just a finalization, I guess you could say, of the documentation that has already been put on the record in regards to our correspondence, not with me in the court.
So, have you received that yet, Mr. Borkin?
I have, Your Honor, and I'm prepared to address that when the court would like.
Well, I'd like for you to send it to the court, please.
I'm sending it this moment.
And the other question I have while it's on its way, is that from Washtenaw County or Ypsilanti Township?
It appears to be from Ypsilanti Township.
Yes.
Thank you. Mr. Day, I need you to take an oath at this time.
For what is this for?
If you're going to give testimony, you need to take an oath, sir.
Oh, okay.
Will you please raise your right hand?
As I stated, I will affirm to with you to take an oath. Yes, but I'm not a United States citizen, so I don't raise my hand or
So
do
you're
anything.
not going to take the oath, in other words?
No, I will, but just not as I'm not forced to assimilate to how you guys do things. That's
The way we do things is for you to raise your hand so you can make that affirmation. If you're refusing to raise your hand, then you're not making the affirmation.
well, then that'll be a violation of the American Declaration of the Rights of Indigenous Peoples. I have the right to self government. That is federal
Okay.
law as well as
Then
international. You, as a agent of the state, are required to make what is the word? You're required to make certain accommodations for uh, foreign individuals in regards to the handling of uh, court cases or court manners, or I'm not sure the proper term, but you're required by law, state law, federal law, and international law to accommodate me in my religious beliefs and my religious way of life. Because if you don't, that'll be a violation of my life, liberty, and pursuit of happiness. It'll be a violation of uh, the uh, Bill of Rights, Amendment 1, um, the First Amendment.
how do you, sir, think that you can bring up the Constitution and your rights under it at the same time that you say you're foreign and it doesn't apply? That's always been a question I have.
Well, the issue is because though I am foreign, the Constitution is the supreme law of the land to you, not to me, but to you all.
Oh, I see.
Yes, as I said, I
That-
come under the Constitution of the Moorish National Republic of Peace, which is a de jure government recognized as a de jure government. And that's the Constitution and the laws and the bylaws that I am under and that I am that has jurisdiction over me. The court and the plaintiff have yet to prove subject matter jurisdiction or uh, personal jurisdiction, and I've raised the issue, and it's been swept under the rug. It's not been addressed, and a jurisdiction can be.
I denied your motion already, sir, several times.
Again, that wasn't a motion.
You know what? The reality is, you don't like the ruling. That's on you, but that is the ruling.
And that will be a violation of your judicial code of conduct.
Okay, cool.
All
right, sir. All right, I am reviewing this notice here from the Charter Township of Ypsilanti, which indicates that there are violations of provisions of the Property Maintenance Code and Rental Property Ordinance, Chapter 48, as indicated here. But I don't see any boxes checked. Mr. Borkin,
Yes, Your Honor.
have you reviewed this documentation? You said you had something you wanted to say about it.
I have, Your Honor, and I have the same issue. I would question its validity, as well as its place in the hearing today, if it doesn't even have a violation checked. Potentially it's a notice, but it doesn't seem to be a notice of any sort of information about a violation.
Mr. Day, is there some part of this document that we're missing where there's a code violation box checked? Because I don't see one on here.
That's just what the agent of the township put on the door, and what she stated was that they're in violation, which I already knew. So
Mr. Day,
I can't speak to that.
Mr. Day, as I look at this document, I'm asking you a simple question. Do you see a checkbox as simply a picture that I cannot see?
It may be. I don't know.
All right. Well, Mr. Borkin, my concern is that I think we need to talk to the Charter Township of Ypsilanti to make a determination if there is some type of violation. Are you able to call over there to see if you can reach someone?
I am. I could do that today if we could set this aside for just a moment.
All right. I want to pass this case.
Thank you, Your Honor. I'll do that right now.
We'll be on a brief recess. All right, the 14B District Court is now back in session. All right, we're back on the record in the case of Country Meadows Apartments versus Tariq Day and Erica Witherspoon, case number 23C0276.
Good afternoon again, Your Honor. Christopher Borgen appearing on behalf of the plaintiff.
Good afternoon. You're muted, Mr. Day.
Sorry, I'm Tariq Samar Tariq Day, citizen of heaven.
Thank you. All right, Mr. Borkin, were you able to reach anyone at the township offices?
I was, Your Honor. I called and spoke to two people at the Charter Township of Ypsilanti Office of Community Standards, and I did find that this notice is legitimate. However, having said that, and having reviewed some of the Ypsilanti ordinances, I can say with confidence that I don't think it's relevant for today's proceeding, because my client still has the ability to charge rent even having failed an inspection. Yes, the notice does say that the tenant does have the ability to place rent into escrow. However, the result of failing an inspection or having a reinspection or the need for a reinspection only involves, for the purposes of the ordinance, a new certificate of compliance. It does not involve the landlord's ability to charge rent. My client does have a certificate of compliance. It continues to be valid. However, they do have a couple items to follow up on Mr. Day's property, but it does not affect the habitability. It does not give credence to Mr. Day's counterclaims, and I would still ask a court for a judgment today for non-payment of rent.
I understand what you just said, Mr. Borkin. However, my concern is you can say that they have the ability to charge rent, which they do, but he has the ability to escrow that rent. And I mean, whether you're disputing whether he's escrowing it properly or not is something I haven't addressed yet. But he's also, I don't know the nature of the actual repairs that have not been done, and they may get to the point where he's entitled to some type of an abatement. So I can't give you a judgment without knowing the nature of the repairs or lack thereof.
My request, Your Honor, would be to come back to court once my client is in perfect condition with the city. I understand the repairs that do need to be made are relatively minor. However, I believe the court's concerns are valid, and we should certainly not be pursuing a judgment today. Would the court be amenable to adjourning this until my client can resolve those issues at their apartment?
Mr. Day,
Yes, ma'am.
I do have to give you an opportunity to weigh in at this point. What would you like to say?
Um, well, first, I just wanted to go back just a second, in regards to um the my statement or testimony being on the record. It's just on the record because I just wanted to make sure I was
On the record, you're not under oath, sir.
correct. So, okay, I think could you elaborate on that? I'm not comprehending. So, is my testimony not valid then,
I'm
or
actually not right now. I'm not taking testimony from you. Right now, I'm trying to ask you what your position is with respect to their request to adjourn this to give them time to make the repairs.
well, I've sent my correspondences, and I said that you said that I wasn't able to seek a judgment, but had this notice not come up, then would you have allowed Mr. Borkin to seek judgment? Because I've
Yes, because he filed an action and he's entitled to a judgment in this case. You have not filed any action, and so therefore you can't seek a judgment.
ma'am, my claim was a valid claim. I made valid claims to the property and to the trust property. I've made valid claims through
So there is
my
no trust
application.
property, and I've denied that motion. So can you please answer the question as to whether or not you are going to dispute their request to have an adjournment?
I truly feel that I'm being uh discriminated against, and my rights are being violated. I've stated on the record that I have a right to self autonomy and self governance as according to international law and federal law.
You've said that over and over again. You've said you
Yeah.
filed a grievance, and my position remains the same.
That you agree that you're violating your actions are violating my
No,
right.
I never said that, sir. What I said is your motion is denied.
But ma'am,
I'm
it
not going to keep going in circles with you about this, Mr. Day.
and that's discrimination, ma'am. Is there I could I uh I'm putting a formal request for the transcripts
You
of
do that in writing. You've done that already. They've told you the procedure. You can do it for this hearing as well.
okay, but that procedure is a forced assimilation. That's forcing me to assimilate.
Sir, you need to answer the question that I have put before you.
Well, under threat, duress, and coercion, since I'm feeling threatened, I'm under duress and I'm being coerced into answering this question. I
Okay.
will answer the question,
Okay.
and uh, I uh, feel that, man, I'm feeling very anxious because I feel like I'm being discriminated against, and I don't feel good about the actions that are taking place right now.
I understand that. You've made that very clear. That is why you filed a grievance. Nevertheless, at this point in time, the question before you is whether or not you're going to object to them having an adjournment today. All right.
Ma'am, I'm having a hard time right now because I'm doing what I know to be correct, and I feel I'm being
You don't,
manipulated
but
for it.
you're all right. Mr. Borkin, how long will your client need to get the repairs together?
Your Honor, I believe a time span of 2 weeks would be sufficient. Um, Cheryl, could you interject to tell me if that's not enough time?
Yes, 2 weeks is good.
Well, Mr. Borkin, we're not open on the 7th. That's Good Friday. Let's go. Are you available at 2:30 on Friday, April the 14th?
I would be, Your Honor.
Mr. Day, you need to be back here on Friday, April the 14th at 2:30, sir.
And again, I don't understand, how do you ask him if he's available, but I don't get that same courtesy? That's a
You're
discrimination.
not an attorney. That's not a discrimination, sir. You're a defendant in a.
Being an attorney has nothing to do with my availability. And that's another reason why you are in violation of your judicial code of conduct. That's impropriety.
Okay. Are you available or you're not? You're gonna say
I'm
no?
not available. I'm just like I wasn't available. I had to take off of work today.
Well, so you're gonna have to take off work. That's the point. He's an attorney and you're a defendant in a case.
And I won't be available that day.
Then you won't ever be available, will you? This always.
That's not correct. But I won't be available that day.
That's the day it's gonna be on. Okay. You need to be here on April the 14th at 2:30, sir.
So where does this leave us? At the end of this hearing, Judge Washington makes a measured and legally sound decision. She does not grant a judgment for non-payment of rent. Instead, she adjourns the case, giving the landlord time to address outstanding repair issues and allowing the court to gather clearer evidence before making a final ruling. That's not favoritism, it's due process. Despite escalating tension, accusations, and repeated challenges to her authority, the judge consistently focused on one thing: making sure the record was complete before ruling. And while Mr. Day's arguments about jurisdiction severely undermined his credibility, his claims regarding housing conditions and chemical exposure were not dismissed outright. They were deferred for proper evaluation. This case is a powerful example of how valid tenant concerns can become overshadowed when courtroom procedure breaks down. It also shows how patience from the bench has limits. Now I want to hear from you. Who do you think handled this better? Did the judge go far enough to protect the tenant, or was she more patient than most judges would have been? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.